We will get started. Hello, everyone, and welcome to the first panel of 2022 for the Los Angeles chapter of the International Game Developers Association, covering employee rights and inclusivity in the workplace. My name is Ross Stillian, and I'll be hosting the panel tonight. By way of background, I'm an attorney. I've been practicing for about 7 years, 4 of them as a litigator, and the last 3 working in-house, focusing more on transactional work. The company I work for is actually a construction and real estate development company, and I just happen to really love video games, which is why I decided to join the IGDA and become a board member for Los Angeles. I've been in Los Angeles for well over a decade now, between college and law school. And for all of its faults, I love it here. So, with that, I'd like to get on sort of the topic of the day. We talk, this is obviously IGDA, game development. Video games, I think, are a wonderful medium. They are an incredible place for inclusion. The games themselves have, no limit to their settings, their characters, the stories, that you can tell. And the barrier to entry is low to non-existent in a lot of ways, even for those with significant physical challenges. Perhaps, my favorite story is with Terry Garrett, a man who's blind, who was able to, beat The Legend of Zelda with community help. And that's one of the great things about the video game community, is that it's, so wonderful, but it is also known for a little bit of its toxicity. And obviously that seems to be bleeding into the larger companies. We've had recently Blizzard Entertainment and Riot Games in the hot seat for sexual harassment and discrimination claims. Riot Games recently settled their lawsuit for $100 million. So that's why we thought here at IGDA LA we would have these 2 panelists here, Alexis and Joanne, who are experts in their respective fields, to discuss employees' rights and inclusivity in the workplace. Alexis Gamliel is the founder and principal trial attorney for Gamliel Law, an elite litigation firm focusing on personal injury, wrongful death, and employment matters. Alexis utilizes her deep litigation experience to stand up for individuals who've been wronged or whose rights have been violated. In her employment practice, Alexis handles a diverse array of discrimination, harassment, retaliation, wrongful termination matters, and she has a particular affinity for representing clients in pregnancy discrimination, gender discrimination, and sexual harassment cases. Joanne Coffman is an HR consultant specializing in talent management, human resources, and talent acquisition. She's spent the last 20 years working with all sorts of companies, big and small, in communication, marketing, and other creative industries. Did I miss anything, Alexis or Joanne?
No, thank you so much. And I really appreciate you having both of us here today. I was so thrilled to be invited to speak, and I myself am looking forward to hearing Joanne's perspective. And I think it'll be hopefully very meaningful for everybody listening to have the employee attorney perspective, as well as an HR informed perspective as well. And kind of along the lines of what you were talking about, focusing on this narrow field of video games, I myself think it is very important for an attorney in my position to really know the industry in which you're representing an employee. And I have represented clients across many diverse and unique areas over the course of my career, but I'm thrilled to be learning more and engaging more with the video game industry. So thanks a lot for having me. Looking forward to this talk with you all.
Absolutely.
Yeah, likewise. Thank you so much for having me as well. It's always exciting to get to learn new industries, and I think that we all have some shared experiences, and that we can learn and grow from each other. This is a very interesting time for both employees and employers, and I think just keeping everyone on their toes with the changing developments and how we treat people, and making sure that we're kind along the way. So.
Excellent. And then just as a bit of housekeeping, as we're going along, we'll probably be, trying to have a conversation here, but any of the viewers can ask their questions in the chat and we'll try to get to what we can at the end of this. So feel free to type them in the chat as we go in case you forget them, and we'll try and get to them later. Sound good? All right. So earlier I mentioned that, we've got, big companies, Activision Blizzard and Riot Games. I believe it was Activision Blizzard just got bought by Microsoft for, I want to say just under $70 billion. So this is a big company. You've got, tens of thousands of employees, and Riot Games is no small, fish in the sea of this. Do you think there's anything special about the video game industry that would, sort of lead to these claims of sexual harassment and discrimination that have been, launched against these companies, or, or is it just the way it works when you get too big?
Well, Ross, it's hard to make overbroad and general sweeping statements about one industry in particular, but I think probably what most of us could agree on in this call is that traditionally the video game industry has been male dominated. Now that may have something to do with it. I can't sit here and say that I have scientific evidence that that is the case. But if you look at, across the board, the numbers of how many women are in these companies and are, either they're the software engineers, they're the animators, or, different roles within these companies, you might see that traditionally speaking, those have been more dominated by males in those roles than women. So anytime you have a significant imbalance of one gender over another or one group over another, there is going to be some greater level of sensitivity that needs to happen to the group that is less represented. And we can only speculate about what goes on a broader scale, but it really is very case specific when you're looking at what goes on within a company. So it comes down to the people, as in any industry. That applies to the video game industry, but we do have to go back and look at the history. So I'd love to hear Joanne's thoughts on that too.
Yeah, I would agree. I think, historically it's been very male dominated. I think as the years change, we're seeing more and more females join these organizations. And a lot of these smaller companies get swallowed up by large companies. So they are small to begin with. They have exponential growth, either through the growth itself or through acquisition. A lot of times policies and procedures may get skipped along the way, maybe not, just because of the speed in which things happen. And sometimes HR policies and the training is put to the side or maybe not paid as much attention to as we need to. And then as we see more and more female creatives and female developers and programmers emerge into the workplace, we're not really prepping our workforce for it as well as we could. And working with our managers during the interview process to just understand how they've led diverse teams before. So diverse could mean anything, right? It could be male, female, it could be different ethnicities as well. So just kind of understanding that growth, I think can kind of set us up sometimes if we're not ready for it, for a little bit of failure in the interim. And then if we've had longstanding employees who've always done something one way and may just be like, oh, we always did it this way, it was no big deal. They're not necessarily prepared for some new rules or some new precautionary areas. So.
And I think that's right, Joanne. One important thing to note is what is going on with the policies and procedures, and are those elements keeping up with the demographics of the employees within the company? And I'll give you an example. I was recently vetting a potential case for a woman who is 7.5 months pregnant, and she is in an HR role in a company, and she for months and even years has, documentation going back this time saying to the higher ups, listen, when the time comes, we need to have these policies and procedures in place. So we have protocols to follow. So it takes the policies keeping up with the reality to really make change and to set up a company for success. Joanne will talk all about the company perspective, but for me as an employee's attorney, looking at that from the opposite lens, that's what I would hope for in a company, is to say, you know, we need to prepare for this evolution and to keep up with the reality that's happening, that we have female employees, so we need to have policies and procedures in place for what happens when those people become pregnant, if and when they do. That's just one example in a narrow subset, but the broader theme is that we need to have these protections in place on paper so that we have guides to follow when, you know, these things happen in reality.
Yeah. And I think one thing, you know, I've always partnered with Employment Council on my side of things when we're growing companies, especially when they go from 25 to 50 to over 100 employees. We have different protections that fall into place on a state and federal level. And I think one of the big leadership feedbacks that internal HR often gets from their CEOs is, if you put too many policies in place, you're going to affect our culture. We don't want it to be too corporate, especially in the creative space. You get a lot of leaders who are like, no, we're gamers, we're cool, we want to be cool, we don't want to look like, you know, a corporate institution. So that's some of the feedback that HR leaders often get. And you're like, okay, but we need to protect the employees, we need to protect the company. And if not, what we're going to do is create toxic cultures that can breed a lot of issues and damage us reputationally. So, you know, that seeps into talent acquisition and all the things. And obviously then Alexis comes into play. So I think, you know, that would be one of our challenges. We grow these companies that go, you know, started with 10 kids in a room developing some cool video games and ended up being a population of well over 2,000. And the leaders along the way are going, but no, we're cool. We don't want to impact that culture with a thick handbook. And it's balancing that fine line of creating policies and procedures that protect the population and can really make employees feel comfortable and protected, meanwhile also not jeopardize. It's all in how you communicate to your population and making sure people feel that the culture is not being impacted, but you're protecting them along the way.
Beautifully said. I wish more employers had that mindset.
Me too.
Yeah.
Excellent. I mean, so listening to you both, it sounds like there's definitely a big potential, you know, problem when you grow things, you know, bigger. And, you know, some of that I think is, even for the employee, they may not know what what should be in place, and that should really be on the responsibility of the employer. But, you know, at what point do you think, you know, what would be the factors maybe a person should consider when they think to reach out to HR within their company, or maybe even outside counsel if they think something's, you know, really gone awry?
I'd say for my, oh, sorry.
Right, Joanne, go first.
Yeah.
You know, I always hope that, you know, when I'm working with my companies, that employees feel comfortable reaching out to me first before they go to outside counsel. And if they do, then that means that I've got a good relationship and have that comfort level. Oftentimes what I've seen in the past is employees are reaching out to outside counsels because they've got to this point of no return where they just feel like they've hit a wall of communication. So that's always, that to me feels like a bit of a fail. Like I couldn't protect that person. But I also understand that they're, you know, sometimes they may just feel like they need to get that extra voice. And the HR teams need to work hard to develop that trust with the population, so that employees can come to us and not just be like, oh, we're just going to go tattle to the CEO. There's going to be a confidential conversation that can happen. So that they feel like they do have a trusted outlet and a trusted partner from an internal perspective.
Yeah, I think it is really important for employees who feel that they've been discriminated against, retaliated against, wrongfully terminated, whatever it is. If they feel like something just isn't sitting right, you need to trust your intuition. And by the way, none of what I'm saying is is concrete legal advice, and it shouldn't be construed in that way. It is very important for anybody listening to this to consult with an attorney if you do feel that way. And obviously, you know, if you want to reach out to me after this, I'll be happy to speak with you. But the bottom line is, for an employee who's in a position where they feel like something is just wrong, you have to listen to your heart and that voice in your head. And then, you know, it's important, if you are feeling that way, to document what's going on, whether that's to yourself or to, you know, as it's happening, by the way, because these things can be used later on and they may become necessary later on, your notes to yourself, but also to contact those people internally, because if they are an upstanding company and they want to do the right thing, they will take those notes and, you know, those emails where you're expressing concern over what's wrong or what you feel is wrong. And hopefully they'll take you seriously, sit you down and try to right the wrong. That's the ideal.
Yeah.
First of all, the ideal is that nothing happens that makes you feel that way. That's preliminary, right? But let's say something like that does happen. We need to raise these concerns. They need to be raised not only for yourself, so that you're standing up for yourself as kind of the first step, but then also to at least allow your employer to do the right thing as kind of like the backstop. And then as the final backstop, if they don't do the right thing after several, you know, after you have voiced that concern, then you talk to somebody outside. But you really can talk to anybody at any point along this journey, but it's a good idea to exhaust these, you know, these steps as well.
Yeah, and I would just say, you know, anytime I've been in an exit conversation, I personally have never asked anyone to sign on the spot. I don't think that's right. I want them to, if it's a situation where someone's departing the company, I want them to take it home and sleep on it. I want them to feel like they've had the time to consider, to meet with external counsel if they want. I'm not afraid of that. And I think, you know, HR practitioners that are really confident in what's going on and they're confident in the facts, probably feel similarly in that, okay, well, I know what's going on unless you tell me otherwise. But yeah, I definitely ask people, don't sign right now. Think about things. Call me if you want to chat. I try to open it up as much as I can, so that there's an open dialogue, and so that it doesn't feel like, oh, so the only person who I can talk to is my lawyer. And that's no offense to Alexis. That's trying to make sure that there's goodwill along the way.
Sounds really important. Alexis, you mentioned something that I definitely wanted to discuss during this panel, which was documenting the, you know, what's going on. And I think it's important probably to do, as I assume both of you will tell me, but I'm kind of curious if there's, you know, what each of you would be looking for. I know sometimes HR also has to deal with a little bit of he said, she said, you know, sort of maybe even office politique. And I know as an attorney myself that is often the crux of a case, you know, when you're taking it to trial. So what is, or what, you know, kind of documentation, what events are you really looking for are most helpful, or you see people not doing enough of that would have been helpful, you know, for your respective roles? Alexis, you can take this one first.
Sure. So there really are two layers to this, because if you're looking at it from how do I prove a successful legal claim, you know, later on down the road, that's one way of looking at this. The other way is understanding that if you do make a complaint of either discrimination or harassment, that you could then also be retaliated against potentially for raising that complaint. And that's a real concern. And that's something that causes fear in employees in terms of them taking that step of documenting things. But the law does protect against retaliation. And that's something that we can discuss a little bit more later on in the talk. But, you know, if you are complaining about discrimination or harassment, complaining about those actions close in time to when they're happening, i.e. immediately thereafter, is much more powerful than complaining about those things months down the road after maybe other things have happened, or it might seem disingenuous for whatever reason. So the proximity in time of the event about which you're complaining is very important in regards to the timing of making that complaint, but then also understanding that yes, as a practical consequence, it's possible that an employer does retaliate against an employee for lodging that complaint, whether it's verbal, and there's no rule against a verbal complaint, by the way. It doesn't mean that it doesn't mean that it's somehow, didn't happen. Of course, a written document is much easier to point to later on. It has a timestamp, usually, obviously, if it's an email or if it's through some app or portal that your employer provides. So documenting is important. I think, everybody could agree on that. If you have a piece of paper, it's probably stronger than if you had an oral conversation. But, just keep that in mind, that there is the potential for retaliation, but the law also does protect against, employees who are retaliated against for providing, good faith complaints of discrimination or harassment. Whether that's, and we haven't even gotten into all the different types of harassment and discrimination, and, but it runs the whole gamut. But like I said, when you're having an issue and you feel that there's something tells you that it's unlawful, raise those concerns.
I would just add to that. I think even if it's not that you feel it's unlawful, it's that it just doesn't sit right.
Right.
It can't to send a quick follow-up email to say, hey, to confirm, this was our conversation. This is what we agreed to as the result. And I think just for your own edification, if you never see that email again, cool. But if you find yourself writing more than one of those emails, then that it is good documentation for yourself, but helps also tell a story to not only outside legal counsel, but to HR. So I think when, someone's coming to HR and it's not the first time something's happened, and you can point to this documentation, it kind of helps us do the investigation as well, to be like, okay. And what isn't discussed a lot of time with HR is if we've seen other situations or similar kind of grievances with a superior or a leader who's managing a team, and there's maybe a lapse in communication where you're like, actually, this person just needs some communications training on tone or what have you, or maybe it's a real issue. We want to get to the bottom of that so it doesn't create a toxic environment for other people. So it helps us really evaluate trends. So anytime you can put that in writing it's helpful.
Yeah, that's a really good point. And if you don't do it for yourself, do it for the society of the company and society at large. Like I'm talking, a little bit philosophically here, but think about it. You have a lot of power, not only as a witness to your own situation, if you are going through something, but also as a witness to the general culture of the firm or of the company or whatever it is. So it's really, really important to be that voice, not only for yourself, but for other people. If there's something wrong going on, and if you witness another employee being harassed or another employee suffering from discrimination, you can vocalize and document those concerns as well.
Yeah. It does help, when we're looking at leaders, sometimes like this team has more turnover than other teams, and then you start getting whispers and you're like, so we see, what's going on here. It kind of gives tips to what we may think is going on, but oftentimes they're not coming to HR all the time. We don't know till it's almost too late. So having those initial heads up gives us a sense to look into things and to pay attention a bit more, or to just kind of knock on doors and be like, hey, how's it going? And just kind of do those check-ins that we need to do.
And I would also mention that the more specific you can be about whatever it is that you are complaining about, the more credible and the more seriously I think your complaint will be taken. And Joanne, obviously, from your perspective in HR, I'm sure you would agree with that. The more that if an employee is coming to you with certain quotations that have been said, derogatory remarks, racist remarks, sexually harassing remarks, the more specific you can be, the better. And also that goes with not just verbal statements that are made that you find that you as an employee listening might find offensive, but also it goes for, inappropriate touching. If you feel like you're not being paid equally in comparison to your male peers, if you're a female employee, things like this, all of those, if you have the same position as a male employee, but that male employee is making 3 times what you're making, those are things that I might raise in a written complaint. But like I said, the quotations, certain sound bites, names, remarks, those things that are made to you should be documented if they don't sit well with you, like Joanne said.
Absolutely. You mentioned that they're, the protected classes. So, for for those listening, federally, there are sort of the classically protected classes of race, color, national origin, religion, and sex and disability. Those are federally protected. So that is the bare minimum any state you go in the United States. But the states are allowed to add more to that. And California protects things like age, citizenship status, genetic information, gender identity, medical information, as well as a few other things. As far as your experience goes, where do you see probably the most discrimination or harassment as far as those protected classes go?
So in my practice, it really runs the gamut. I think it's not that so what I could tell you what I see more of. But I think that might not be representative of the entire community. I think it's important, especially for, and this is just my assessment from what I've seen. I think that I do get a lot of young women calling and asking for legal advice. They want, I believe, from statements that I've heard, that they want a lawyer who can identify with them. I do also have clients who are not young women who run, all sorts of different demographics as well. But so in my practice, I just happen to see and hear more about gender discrimination, sexual harassment, and pregnancy discrimination. But I also have a fair amount of retaliation cases that I'm handling across diverse industries. And so, I think in today's world, there is a lot of an emphasis on gender discrimination. I think that especially with what's going on in the socio-political climate as well, there's a lot of awareness about gender equality and how it needs to be implemented better and stronger. So that's kind of what I see more of in terms of my practice. But that doesn't necessarily mean that those cases are more prevalent across the board.
Right. And Joanne?
I think, what I've seen, it really depends on the practice. And my space really varies. You get some shops that are more female dominated. In those cases, it really depends on whether it's more related to the ones you get a very low population of women having children. So it's more discriminatory against like new mothers. Whereas if you have a heavily male dominated culture with very few females sprinkled in, that's when you get more sexual harassment. So it really varies by kind of the agency or the shop, if you will. And it's a really wide range. You get a little bit of everything. I do see, I work with a lot of, with more female dominated organizations where you get, 25 females to 2 men. And in that you get some mean girl situations. And you get bullying, and so that's something that is new to see emerging. And I think you'll see a little bit of that in the gaming industry as well, when you have all the mostly men in kind of a frosh week sort of mentality of hazing for new people as well. So it may not necessarily be discriminatory based on protected class, but it may be based on new people coming in and them earning their keep, so to speak, and some practices that probably should should long go away.
Yeah. And I mean, it all goes back to inclusivity, and the law is founded on this idea that because of immutable characteristics, we should not face different or disparate treatment. You know, and this tenet of equality, when it's not respected, that's when I get involved. And it can be for a wide variety of different protected classes.
That makes a lot of sense. So I understand obviously that it's very, you know, industry and sort of case dependent and everything like that. Have either of you noticed a change in, I suppose for you, Alexis, would be the people coming to you and the problems that they're having, and Joanne, you know, maybe just the kind of complaints, the form that, you know, maybe the problems take in the context of COVID and, you know, a lot of work from home now. I mean, do you see, is it worse? Is it less? Is it the same song, just a different verse? I mean, what do you, have you noticed any differences, you know, in the last 3 years?
I think my 2 cents is I think that some employers have used COVID as a license to implement whatever decisions they have wanted to implement. And it's easy to point to COVID as a pretextual reason for a termination or for a disciplinary action or a suspension or whatever it might be. Even if the actual animus behind the action is discriminatory or retaliatory. This is a very jaded view of the world because of my profession and because of where I sit on my side of the aisle. But I do think, you know, with every case, you have to look at the facts before you and understand what are the dynamics, what are the actual circumstances of each interaction that's being presented to me as somebody who's listening, you know, from the outside at first. And I am very careful with vetting my potential cases and looking for the documentation up front. So going back to this point that we talked about, the proof is in the pudding. I need to see, you know, there may not be, you know, a smoking gun in every case where it says, let's terminate this person because they are X or Y or whatever it is. But you have to look at things from a bird's eye view at first and then drill down and get to the evidence. So when I'm talking to potential clients and, you know, I'm listening to their story, I ask, okay, well, how are the other employees who are similarly situated treated? Is it something that has to do with your protected class? Have you had performance issues before? Be candid with me. You know, are you on a performance improvement plan at the time that you're terminated? Did you fail to meet the standards that you needed to meet to continue your employment? You know, and it's all about reading between the lines. Employers are very good at papering their file in their favor. You know, we have to be honest about that. And so it's all about looking at the full picture and the totality of circumstances. And you know, so each case is very specific. COVID, I think, as I mentioned, is sometimes pointed to as a pretextual reason for reduction in force. So I definitely saw a huge uptick in the potential employment matters coming my way during the COVID era.
I would agree with that. I think two things I've seen is one, during 2020, so not so much now because it's died off, but during the initial months of 2020 when COVID first hit, it's probably March through July, saw some leaders who weren't dealing with the stress of COVID so well and leaned into some bad behavior then and just blamed it on COVID and thought it was licensed to behave poorly. Now, that didn't help anyone because I think everyone was dealing with the stress of we're in the middle of a pandemic that we've never seen before. So it's no excuse, but that definitely came up. The other thing I saw, and this now is now going to be a permanent problem, if you will, is just communicating online. So tone is taken out of context all the time. We communicate through Slack, we communicate through Messenger, whatever your tool of the day is. And oftentimes, leaders and employees alike will hide behind nasty emails which could have been a very polite phone call or a very polite Zoom meeting, but they'll send something that is just egregious over email. And then of course it gets into war. And this, unfortunately, because we're working remotely and that person doesn't sit 2 desks away from you anymore, I think that's becoming more prevalent in that just the nasty grams are coming out large, which ends up in Alexis's desk, because then you get, toxic workplaces that could have been prevented with a simple like, hey, I didn't get what you said there. So I've always had a general rule with the teams I work with is, before you send that note, hey, but pick up the phone and be like, hey, I don't understand what you said there. Can you explain? Rather than like launching into a nasty note that was taken completely out of context, but becomes a war. And then possibly becomes a toxic situation between an employee and a colleague or a supervisor. I think sometimes we just need to learn to communicate a bit better.
That's an excellent point. And I think that the greater prevalence of written communication in this COVID era is something that really does cut both ways. Because on my side, I have more documentation to support what my clients are saying, which obviously puts them in a better position when I can go to bat for them and fight for their rights. But at the same time, it's just, it's not good for the employer, right? Like, but in looking at things from my perspective, I'm a trial lawyer. So I think about, how is a jury going to read this email at the end of the day? How is the jury going to look at the tone of the Slack message? And not just one of them, but all of them stacked against one another, right? So when I'm reading those emails, I look at them from a totally different lens. And I don't think it would be, obviously each email is its own document, right? But when you stack it all against, when you stack them together and you present them in a packaged bundle to the jury and you say, what does the evidence show? And the standard is only a preponderance of the evidence when you're in a civil jury trial, meaning that just by a feather's weight, if the scale tips just ever so slightly in the plaintiff's favor, then they win on a particular issue. Then I feel like, it's a really hard battle for an employer. I think looking at things from both perspectives is always important. But at the end of the day, I try to look at things from a juror's perspective. And if I'm convinced that this is persuasive enough, then the employer needs to be concerned.
Oh, no, without question. I think, that's at the end of the day, as the employer, we're trying to create environments where people want to be there, enjoy the work they do, the colleagues they work with. The last thing we want it to become is toxic. And that employee leaves, and then there's bad faith and reputation issues, and then obviously employees who have like long-term post-traumatic stress disorders because of an experience within the workplace. So I think yes, definitely we want the documentation. It obviously helps HR determine where some toxicity may exist or stem from. But at the core, what we're looking for is to create environments where people want to come and work and like just do good work and be creative and have a little bit of fun with their colleagues. And I think the gaming industry is the pure example of people who really want to come to a place to have some fun. That's why they joined the gaming industry. It's similar to that in the creative industry. They came to do cool work and create great ideas for cool brands. So our goal as HR professionals is really to create those environments where they can thrive and do that without having to worry about calling Alexis down the road, and really be in a position where folks can focus on the work.
That makes sense. So earlier, Alexis, you mentioned retaliation, and I do think that's a good topic for this, especially because it's sometimes it's where the real damage is done, because someone could have correct me if I'm wrong here, but essentially retaliation is something where someone does something they're legally allowed to do, and the company doesn't take it very well and does something to make their life harder or ruin it in some sense. So where does that begin and end as far as retaliation? That they're what are people allowed to do that employers often are found retaliating against? Not that they all have to be doing it. And then what are maybe the subtle or not so subtle ways you see retaliation take place against those employees?
Sure. So retaliation cases are really interesting because it's almost, I believe, I believe to be one of the most egregious paths that an employer can take, because there are two different types of retaliation in California. There's retaliation under the California Fair Employment and Housing Act, and that means when an employer retaliates against an employee for complaining of conduct that's otherwise protected within the California Fair Employment and Housing Act. So what does that actually mean? That means that if you complain of retaliation, if you complain of harassment or discrimination, generally there's also some other things in there, but these are the broad strokes, and you are punished or penalized or suffer an adverse employment action from your employer because of that complaint, then you have a retaliation claim. Similarly, there's also, what I call whistleblower retaliation. So if you engage in a protected activity, such as complaining of some violation of the law or what you believe to be some violation of the law, and it doesn't have to necessarily be discrimination or harassment, and you suffer an adverse employment action because of that, then your employer can also be liable for retaliation. So these are two different buckets, and the easiest way to kind of illustrate these two types is by way of example. So let's say you're an employee and you've been sexually harassed, and you complain of that sexual harassment to your employer, and then just a week later you're terminated. That's an example of the California Fair Employment and Housing Act breed of retaliation. And then if you're looking at what I call whistleblower retaliation, you've probably heard this term in the media, right? Like, these are the cases that are the employees who speak up on behalf of society, like, or themselves, and they blow the whistle on what they believe to be unlawful or otherwise wrongful conduct, and then they're punished because of that. So I will give you an example of that type. Let's say that your company is engaging in some unfair business practice or false advertising type of behavior, and you as the employee bring that to your leader or your direct supervisor's attention, and you say, like, listen, the company is doing these things, it's causing me a lot of concern. We publicized this, but we're really doing that, and like, should we be concerned about this? And you lodge this good faith complaint about that, and that would be your protected activity. If you're later penalized or suffer an adverse employment action because you raise those red flags internally, then you may have a case for whistleblower retaliation. So hopefully that kind of like sets the tone for this piece of the conversation, just so like we're all on the same page, because it can be a little bit confusing. We all know retaliation in the common usage form, right? Like, you do something and then you're punished because of that, or you face some consequence because of this thing that you did that you thought was good. But that's kind of the, more of the legal definitions in California and how that works in terms of proving a potential case or proving a case of retaliation. But there's a whole lot of prove up that goes into that too. One of the biggest things that I look for in reviewing a potential case is, what does the timeline look like? And that's actually a really important thing generally when you're talking about discrimination, harassment, or retaliation. What does your timeline look like? Are these actions that are taken one after the other? Are they close in time? Looking at these patterns is important because it helps us understand what are the real motives of these company decision makers. because that's something that's usually proven by circumstantial evidence, not direct evidence. Like I said, you're very rarely going to find that smoking gun. And sometimes, let me tell you, I find them and they are damaging. And I am like, wow, that person really put that in an email. But more often than not, it's more commonly circumstantial evidence. So sorry for that long-winded answer, but hopefully that helps us in this conversation.
No, I think that was helpful. In terms of retaliation, from my standpoint, it's one of those things we always try to make sure that from an employee handbook perspective, not only is the retaliation policy in there, but when we do harassment training, we talk about it and we address the fact that retaliation is illegal. It cannot be practiced. And when it comes down to, if there's a complicated employee issue and it gets to the point and perhaps a leader is saying to me, retaliation can not only mean, hey, I'm going to fire you. It can also mean, hey, I'm going to put you on an account that's miserable. So if you're working on, say, something sexy like Coke, and then suddenly you're working on something horrible like, or just, completely uninteresting, or one of the less sexy accounts of the client, and you're put onto something that like that, and suddenly you're taken off of one team, you're put onto another team, that can be viewed as retaliation. So when I get into, or when I have gotten into the, tricky situations in the past, I call my employment counsel. I think as HR practitioners, sometimes we have to realize, when we have the answers, and if we're unsure about the answers, we need to ask for guidance. And that's a conversation with your leadership team to say, look, we are now walking a line. And so it's important for us to be able to say, we need to maybe from an employer standpoint, invest in that legal counsel and get the guidance. Are we doing the right thing? Are we doing the right thing by the employee? Are we doing the right thing by the company? Because both things are always hand in hand. So I think just pausing before we take action is always key, and asking our legal partners. And I've had, legal counsel for many years that I rely on when those tricky questions come up. So.
Yeah, absolutely. So, I mean, this might be sort of a weird question, and I suspect I might know the answer from Alexis. Do you think, is it ever that the employer or the person, doing the discrimination and harassment just really is that unaware that, it's not malicious in any way? And I mean, I don't know, that they're out of time and place, and they're, they just haven't gotten with the times. And I mean, I wouldn't want to excuse it that way, but do you still see that where people are, making the wrong kind of comments and making the wrong kind of decisions, like in a way just based on who they are and how they were brought up, and they don't actually see the problem with it?
So that's a great question. And I think it's certainly an argument I hear all the time, right? That no harm was meant. But harm is done often. And I, in my position as a trial lawyer and as an advocate for employees who have been wronged, am that enforcer of these, this notion that you should be protected from discrimination, harassment, and retaliation in the workplace. Do I think it's possible? Sure, of course. And when I'm taking a case and I'm listening to a story and hearing the evidence, and talking to somebody who has come to me where their intuition said, I need to consult with a lawyer, usually it's past that point where, okay, I've heard enough evidence. There's no way this is innocent. And I wouldn't take a case where I felt like, oh, they probably meant no harm, and I'm going to go proceed with this, lawsuit anyway. That's not my goal. My goal is to fight those fights that are really meaningful and worth fighting. So you won't find me prosecuting a case like that. And I do think that it probably happens in the workplace, but those are not the cases that I'm after. I do want to represent those people who have presented to me enough evidence, who have really struck a chord with me emotionally, and also as, as a trial lawyer who views these cases with the lens of the jury at the end of the day, from that perspective, because that's how, real results happen.
Yeah, that makes sense. Joanne, for you, like sort of in addition, if you did see that sort of thing, I mean, how would you approach it, and where would you, how would you try to handle that kind of situation to educate them and let them know it's like, hey, this is not okay?
Well, I had a lawyer say to me many years ago, and it stuck, that ignorance is not a defense. So we start there. And as we get feedback, it is our jobs to have dialogue with our managers and with the people who are around them, to be like, hey, you may not have meant it this way, but this was offensive, or this behavior needs to course correct. So I really try to make sure, as I find things out along the way, if we're addressing issues, to make sure that it's not only discussed but documented, so that oftentimes, if it gets to someone like Alexis, this is not the first complaint. This is not the first time we've heard about something. This is accumulation of things. So it rarely comes as a surprise to say so-and-so is doing this and it's just extraordinarily egregious. Every now and then we get caught off guard, but I think HR teams who have a real pulse on what's going on with the company, and I think, depending on the size, sometimes size of the company, you may or may not have more of a pulse on what's going on, but you hear rumblings. So oftentimes places that were like, we had no idea this was happening, as an HR professional of doing this for a long time, you kind of like, really? I'm calling BS on that. It's not necessarily 100% of the truth.
And one thing to keep in mind too, along the lines of what you said, which I love, ignorance is not a defense. I will use that in the future. Thank you for that. Yeah, I think along those lines, what's really important to recognize is in discrimination cases, actually, there are two different subtypes. There's disparate treatment, meaning that you were treated differently because you are a member of a protected class. And then there's also disparate impact, meaning that a certain policy or a certain action disparately impacted a certain group of protected individuals. So, or you personally, because you are a member of that protected class. And in that subset, there's not a requirement that that the employer was knowingly discriminating against, a specific subset of a protected class. So that's kind of, along the lines of what Joanne, you were saying.
Excellent. Yeah, ignorance is not a defense. I think that's thankfully that's most of the law, I think, here in this country.
And there's one other thing that I think is really important to add to that. Sorry to interrupt you, Ross.
No, go for it.
We've heard this term, microaggressions. Microaggressions become macro because they're stacked against one another. And, it's like somebody making a comment like, oh, women are emotional, or this or that. And they're like little one-off comments. But then when it's like time after time and day after day in the workplace, and you hear these kinds of comments, like that's just one example of, okay, maybe that one time he may not have meant harm. Like, let's give that person the benefit of the doubt. Well, let's see what happens tomorrow and the next day and the next day. And at some point, it's undeniable what the actual intention is behind these comments. Is it to belittle somebody because they're a member of a protected class? So a lot of this is common sense oriented. We look at the evidence and, like Joanne was saying, noticing patterns too.
Makes sense. Sort of our final question before we try to move on to the Q&A. My understanding, if you're going to try and sue your employer or previous employer, you've either been terminated already and you're now trying to seek other employment, or you're possibly suing them while you're still working with them, and that's protected, from retaliation, as I understand it. But from both your perspectives, I mean, what can a person, anticipate as far as the difficulties that may create for their life, if they're going to try and pursue sort of like the legal remedies that they have against their employer, especially while still working with them, because I just feel like it's possibly unavoidable at some point, right? Joanne, I think first. Sorry, Joanne, you can go first.
Yeah, that one's tough. I mean, usually if they're to the point of suing their employer while they're working with them, they really just want to get out. At this point, it's become uncomfortable, and not only for them, but for their teams, and they just want to exit and get on with their lives. So I've never seen someone who sued and then stayed working with. I think the end result, anytime I've seen it, has always been a departure. And it's all in how it's managed. And I think sometimes, people get a little hot-headed when they shouldn't. So, and leaders take it personally. I think the leaders that take it personally are the ones that screw it up the most, because you need to separate yourself from the situation. You have to separate the business from the situation. There has to be empathy and compassion. And that's the starting point for me, is just kind of figuring out, like, what is really the end result you're looking for? What are you looking to achieve, and how do we get there together? So from an HR perspective, I try to sit down and say, so what are we looking at? Is this a leadership issue? Is this something that the employee has a problem with? Is it the company in general? Is it culture? What is it? So really trying to get to the bottom of it, because at the end of the day, it's probably not just one incident, and it may be something that we can resolve. It may not be something we can resolve. And then, partnering with that employee and maybe legal counsel as well. It really depends. But often I've never seen employees sue and stay. Alexis, I'd be curious to know if you've ever.
I haven't seen it myself either. Usually when an employee comes to me, it's either in the form of a confidential consultation while they're still employed, or after they've departed, but not choosing to sue while they're still there. And I think, when employees come to me after the fact, it's clear when they've reached the point of no return. And that's usually before I've gotten involved. Sometimes I will provide confidential consultations to those employees who are kind of in the middle of the storm, and they're looking for a lifeline and for some advice. And, in those circumstances, I will consult, but, in that context, I probably, unless there were some extreme circumstances, would not advise against suing and staying. But, every case is different, and I will never say never.
Right. All right, I think we've only got a couple of minutes left, so we'll try and ask some quick questions here, but also try to have some quick answers. This one should be easy. Have either of you seen someone terminated for something they said on Slack?
Yep.
Yeah, getting the yes from Joanne.
Not yet.
Not yet.
It wasn't necessarily Slack, but like an instant messenger, any sort of communication. If you say bad things, it can and will be held against you.
Because HR has access to that, even the Slack channels.
Well, okay, so that's an interesting conversation that's going to evolve. It's a bigger one in the state of New York. Employees now have to be notified that employer channels can and will be monitored. In the past, those things weren't necessarily communicated to teams. So now I expect the state of California may follow suit, just because of the changing practice. This just came out a couple months ago. So employees should know that the communication channels you use aren't necessarily private. HR teams and IT teams alike can dig into those and find the messages, and sometimes those messages have some pretty egregious content.
Okay, thank you. We've got two more questions, one for each of you. I think I'll summarize this one for you, Alexis. Can you record, like, video or audio record in an office, and is that legal, and can it be used in court later?
So this is an interesting question. It has to be if you are recording somebody, it entirely depends on the context. If you're out in a public place, right? Like people pull out their smartphones all the time and record what's going on. I would, confirm what your office policy says about that, or your company policy. And generally, let's say you're having a phone call or a Zoom call, you have to get consent to record that because that is required. But as far as general office interactions, I actually don't know the answer to that. And I think what's important to know is you have to know what questions to ask and what resources to go to. And, so I'd be happy to look into that further.
Sounds good. And then for you, Joanne, you might have covered this earlier, but I think, someone is asking generally for HR, are you sort of, promise to confidentiality if someone comes into your office to, to speak with you and make a potential complaint about somebody else? Or are you, like you said, do you remember you said you're afraid people will think you're going to go rat it to the CEO?
So mostly, and often my conversations start with, so is it, are you venting to me or are we doing something about it? So first and foremost, is there action on the end of this? Also, the other thing that has to come into context is if there's a legal activity that you tell me about, so sexual harassment, some fraud, embezzlement, some sort of like criminal actual activity, legally we are required to do something about it. We can't just bottle it up and pretend like we didn't hear it. So I think it really depends on the conversation in that respect. But if someone's coming in with maybe a complaint about their supervisor, the question usually I start out with, so is this a conversation for you to let me know? Are you venting? How are we going to action on this? And you don't have to answer right away, but by the end of the conversation, I need to know where we're going. And that kind of gives me the understanding of if this is a one-off. If it's a second conversation, I start getting into, we need to start documenting this because this isn't the first time. This isn't that you're having a bad day. This is becoming a pattern. So that's where we have to start looking at, do we have to start addressing things with leaders? And we can do it from an anonymous basis, or, there may be situations where I say, I'd love to meet with other members of the team to see how things are going, like just a general conversation. And from those general conversations with teams, we can start getting some pretty good perspective on whether they're one-off behaviors or if it's a little more systematic.
That makes a lot of sense. We are actually about 2 minutes over. So I think that's actually pretty good as far as going over on time. I want to thank you again, Alexis and Joanne. This has been really, really informative. You both were absolutely wonderful to join us and speak with us about these topics. And I suppose everybody, I hope you had a good session here, and hope to see you next time.
Thank you so much. Thanks for having us and for all the questions too. You were all so engaged.
Yes, thank you.